It is shocking that Mr. Kiari can stand before the court and cherry pick to represent that which transpired the last time we were in court in his favor. For the record, and I believe co-counsel will agree, when we were last in court, the Honorable Okondo indicated this before she began her proceedings, that any substantive applications will be heard before you, Your Honor. And she indicated, quote unquote, that her instructions were similar to those of an advocate holding brief. And any attempt to address any application in that respect was denied. It was on that basis that the accused person took plea. And you will note on the record as well that all applications were to be had before you today. So it is in that spirit that the DPP would be deceiving this court when they indicate that they asked the court to further have the devices held, and they informed the court that, well, the same has been transferred elsewhere. That bail was not granted.
Your Honor, I believe I did not say that.
I am on my feet.
No,
I am on my feet. If that is an objection,
I object, Your Honor.
You will.
Your Honor, I'm objecting. I did not, can court please go to the record. I did not tell court, Your Honor, that I informed your sister about the forms and where it is and the progress, Your Honor. And counsel may have a seat as an object and have at least have some respect. Your Honor, that's not what I told court. I told court, Your Honor, that plea was taken and any subsequent applications were to be dealt with today. Your Honor, and I just told court about the write-ups of the phone, Your Honor, because we've been asked to have it released to the accused person. And I was justifying the reason why that phone cannot be released at this point in time. Otherwise, it will be very improper for counsel to be making those kind of submissions when court has a record that is properly recorded by citizens.
I'm not sure what is the difference between what he said and what I said, but I'll leave it at that for Your Honor to decide. The point I was making before I was rudely interrupted.
Can counsel use some court language, Your Honor?
What part of that is
rude interruption? That was an objection.
It was actually a rude interruption.
Your Honor, please intervene.
I am more than happy.
Your Honor, intervene because this is
I
not
am
proper.
more than happy.
I think Mr. Attalo is in
There
the
is
habit.
a proper way. There's a proper way to address the court.
Your Honor, can you intervene, please?
Let me finish my submission.
Your Honor, can you intervene?
Have a seat.
Can you have control of this court, Your Honor? Please.
Yes, so just Mr. Attalo, let's use and wind up what your agenda.
My point is, Your Honor, there's an appropriate way to move the court if I'm on my feet. If counsel has not done that, it is rude. And I'm more than happy to
Your Honor, is Mr. Attalo not taking the court direction of the
I have taken the court's directions. Just take
Where
a
is
seat.
it?
Let
Where
me
is it
proceed
sitting,
and
Your Honor?
finish.
Your Honor, I'm not going to participate in this manner of behavior. The counsel is becoming disrespectful to me. Utterly disrespectful.
Mr. Attalo,
Yes, Your Honor.
let me ask. Is that a good right or any other?
Yes, with your kind permission, allow me to proceed.
Yes.
Thank you. As I had indicated, the instructions.
You're saying you are directed not to make substantive application.
Yes.
Is that exactly what you're talking about?
Yes, indeed. We were directed not to make any application whatsoever with respect to the phone or otherwise.
Yes.
And so at that point in time, we were even constrained to make any application with respect to the incompetence of this charge sheet. And how it is fatally defective. It should be noted, Your Honor, that no authority has been advanced by the prosecution by way of a court decision with respect to the defectiveness of that charge sheet. In a reiteration of the provisions of section 134 of the CPC do not qualify as a judicial decision of precedent. The authority cited by myself, Your Honor, is a decision of the High Court. And thus binding before this honorable court.
You necessarily joined us, so
Yes,
that we are addressing what.
yes.
Yes.
I'm making reference to the initial authority that I had made by Ibrahim, that is Ibrahim Edan as the Republic. So nothing new, Your Honor.
Can you present a copy of that authority?
I am very much happy to do that, if given a moment. I have it with me in soft law.
Are you now done?
Yes, that is all.
Your Honor, if you could just kindly indulge me for 30 seconds. First of all, kindly allow me to begin with apologies to this court, the prosecution, and all court users for that dispatch. We do not mean to spite the prosecution or anyone else. Your Honor, on to my rejoinder, there are two issues raised by the prosecution. One, that the charges fully comply with section 134 of the CPC. Your Honor, as reiterated, kindly just allow me to point out the particulars of the offense do not conform to Article 50, sub-article 2B. Which state that the accused person has a right to be provided with sufficient detail to answer it.
Article?
Article 50, sub-article 2B. Your Honor, the charge that is before us, as once again as I said, it has various elements and they cannot all be fulfilled conjunctively. Your Honor, at that we will graciously request this court to give us directions on a ruling